Okay, so if you're running a global business, you're constantly facing this incredibly high stakes question. Is that payment you're about to make to a foreign official just a customary tip, what some might call baksheesh, or is it an illegal bribe? The line between a cultural norm and a criminal felony can be unbelievably fine. And the difference? Well, it could mean millions in fines or even jail time. So how on earth do you tell them apart? Let's break it down.
To get a sense of just how high the stakes are, just look at this number, $800 million. That is the massive fine that the German engineering giant Siemens AG agreed to pay to the U.S. government. At the time, it was the largest penalty ever for foreign bribery, and you better believe it sent a shockwave through the entire corporate world. We're not talking about a slap on the wrist here. We're talking about financial hits that can absolutely cripple a company. And this, right here, this really gets to the heart of the problem. You might see a handshake, a gift, a sign of respect, but you know who might see something else? A prosecutor. They might see a federal crime. So what's the law that actually draws that line in the sand? Well, let's meet the main character in this whole story, the U.S. Foreign Corrupt Practices Act, or the FCPA. It was passed way back in 1977 with a pretty simple goal: stop U.S. companies from bribing foreign officials. Now, for a long, long time, it was kind of a sleepy, forgotten law, basically just collecting dust. But that has all changed, and now it's being enforced with a vengeance. You see, the FCPA is really a law with two powerful punches. On one side, you've got the anti-bribery provisions. That's the crime itself, right? This is the part that makes it flat out illegal to offer anything of value to a foreign official. But then, on the other side, you have the accounting provisions, and that's all about the cover-up. This part forces companies to keep meticulously accurate books, making it way harder to hide bribes and slush funds or disguise them as, say, consulting fees. It attacks both the act and the ability to hide it. It's genius, really.
So what's the actual recipe for an illegal bribe under this law? It's not just about a bag of cash. Think of it more like a checklist for prosecutors. First, did the transaction touch the U.S. in any way? Even just sending an email through a U.S. server counts. Second, was anything of value offered? And let me tell you, that term is incredibly broad. We're not just talking money. It could be a lavish vacation, a fancy watch, even a job for a relative. Third, was it given to a foreign official with corrupt intent? That's basically the quid pro quo, an expectation that they'll misuse their power for you. And finally, was the whole point to get an unfair business advantage? If a prosecutor can tick all of these boxes, you are in some serious, serious trouble.
Okay, so we know what an illegal bribe looks like, but the next big question is, who gets in trouble for it? You might think it's just the person on the ground, the one actually handing over the envelope, but nope. The FCPA is designed to climb the corporate ladder, all the way to the top. And hey, if you're an executive thinking, you know what, I'll just make sure I don't ask what our local agents are doing, well, think again. The FCPA was specifically designed to kill that exact excuse, what the courts call the head-in-the-sand defense. Here's the bottom line, and it is crucial. The law says that if you deliberately avoid the facts, if you should have known something was fishy and you chose not to look, that is legally the same as knowing. You can't claim ignorance if you intentionally kept yourself in the dark. In the eyes of the Justice Department, that's not plausible deniability. That's a confession.
And believe me, the consequences aren't just financial. They're deeply personal. This number, 7, represents the 7-year prison sentence handed to a former executive of a Halliburton subsidiary for his role in a bribery scheme in Nigeria. At the time, this was the longest sentence ever under the FCPA, and it sent a crystal clear message. Individuals, not just companies, will pay a very high price.
So, this all brings us to a really critical question. This law has been on the books since 1977. So why are we hearing so much about it now? Why this sudden dramatic surge in enforcement? Something has clearly changed. You can see the turning point right here on this timeline. For its first 25 years, the FCPA was barely enforced. It was a legal ghost. Then, right around 2002, everything changed. The number of prosecutions just exploded. So what happened? Why did this once sleepy law suddenly wake up and start breathing fire? Well, it wasn't just one thing. It was a perfect storm. All of a sudden, investigators around the world started sharing notes. At the same time, you had huge corporate scandals that led to the Sarbanes-Oxley Act, which forced executives to actually pay attention to their own books. So companies, terrified of getting hit with massive fines, started turning themselves in. They also built up their own internal police forces, which, ironically, just ended up uncovering even more problems. It all created this massive feedback loop of enforcement that's still going strong today. So we've looked at the law, the huge stakes, the global crackdown, and it all brings us right back to our original question. For that manager on the ground in a different country faced with a complex local custom, what do you do? And so we're left with this fundamental tension. In our modern global economy, how do you balance respecting other cultures with the cold, hard reality of federal law? As we've seen, there are no easy answers. But getting it wrong can cost you, your employees, and your company absolutely everything. The line is fine, but make no mistake, it is there.